Hi class, my name is Megan Fleury and today I'll be acting as a jury member in the courtroom drama of Plaintiff versus Ashford Hospital. This case was pretty complex. The plaintiff's personal health information was distributed via email to healthcare professionals and providers who also happened to be her coworkers and a supervisor. I think cases like this are going to be popping up and emerging more as we advance more technologically and with the advent and use of electronic medical record systems. It gives employees and healthcare professionals more of an opportunity to improperly disclose information. But I am actually voting in favor of the defendant, who is Ashford Hospital. According to the Health and Human Services website, there are exemptions to the patient consent requirement of the HIPAA law for covered entities. The covered entity in this case is Ashford Hospital. A covered entity is defined as a healthcare facility treating the patient, healthcare clearinghouses, as well as healthcare providers and medical personnel of the facility that's treating the patient. So these exemptions include the use of personal health information for its own treatment, payment, and healthcare operation activities. In this case, the plaintiff's supervisor was given her information and she is seeking financial ramifications because she believes that it was a breach of her privacy on a need-to-know basis. However, hospital administration, such as her supervisor, is heavily involved in healthcare operational activities, and therefore the patient's supervisor is a covered entity under Ashford Hospital and has the right to have access to the patient's information for her duration of treatment through the hospital. According to HIPAA regulations, 45 CFR 164.506, a covered entity must develop policies and that limit disclosure of a patient's PHI, which is their personal health information. While it may be in the interest of Ashford Hospital to revisit their policies and procedures regarding disclosure of information such as this, according to this regulation, they are not in violation of HIPAA, as the regulation clearly states they are not required to apply the minimum necessary standard, but it is only a suggestion. Furthermore, the Health and Human Services website states that a covered entity may choose to obtain individuals' consent to disclose their information for treatment, but that is not required. While this case does not say whether or not Ashford Hospital obtained written consent on the plaintiff, she obviously consented to her treatment and her care there. Therefore, the hospital was a covered entity for her care and able to distribute her PHI according to their policies. The Health and Human Services website also states that an individual may request a restriction placed on the disclosure of their personal health information. It further states that the covered entity, in this case Ashford Hospital, does not have to agree with these terms. But once they have awarded the restriction, they are legally bound to withhold the standards of this agreement. Therefore, there is no evidence in this case of a restriction placed by the plaintiff on her PHI. Therefore, Ashford Hospital was within their bounds legally for distribution of her PHI. And finally, the plaintiff argues her case on the grounds of identity theft through disclosure of her Social Security number. However, reports indicate that financial identity theft costs Americans an annual approximate $53 billion, while medical identity theft, which is different from financial identity theft, costs Americans approximately $2.1 billion annually. And while this is important to factor in, it obviously is a much larger threat in the financial aspect for identity theft than in the medical arena. Therefore, this is a weak argument in that the plaintiff is much more likely to suffer losses from identity theft through her credit cards, her debit card, her banking, and the distribution of her Social Security number in the merchant market versus in the medical setting. So once again, I am voting in favor of the defendant, Ashford Hospital, and that the plaintiff should not be awarded the financial ramifications. I look forward to talking to all of you further about this courtroom drama. Thanks.